Um, we're going to talk about something that everyone should be familiar with when you're talking about the state of Alabama and the Deep South. We're going to talk about race. We're going to talk about racial discrimination in the context of mass incarceration, prosecutors, and jurors, the selection of jurors. Um, this is a copy of my jury strike list. It's 30 names in all. 30 names. Here's number 30 right here. Yeah, it's the last one, number 30 right here. And the first one, right here. It's the first one. Randall Ashford, black male. Out of 30 jurors, Mr. Ashford, I had a total of 5 African American jurors, prospective jurors. Miss Willie Burns, female. Randall Ashford, the first one. Miss Vivian Jennings, Mary McCombs, and Winnie Ross. Okay, out of the 5, there was one male African American on my panel, and that is Mr. Ashford. He's the first person on my list. Y'all have heard of a Batson challenge. That's when a prosecutor strikes a juror based on their race. One of my jurors was struck for cause. One of the African Americans, she was struck for cause by the prosecutor. I forgot the reason. And 2 others were struck what they call peremptory challenges by the prosecutor. Miss Vivian Jennings, African American female. Mr. Randall Ashford, the African American male. They were struck by the prosecutor. And as I said, this is page 177 from my trial transcript. And you will see that the first person that the prosecutor strikes is prospective juror number 1. The state would strike number 1. There's Mr. Robert Lee Broussard, Madison County District Attorney. The state would strike number 1. Mr. Ashford. Who is Mr. Ashford? Who is he? This is who Mr. Ashford is. This is page 85 of my trial transcript. This is Mr. Ashford right here, introducing himself to the court. And this is what he says. He says, "Hi, everybody. I am Randall Ashford. I am a computer software test engineer. I'm a computer software test engineer on the National Missile Defense Project. I am single." And what else was that, Judge? You covered that very nicely. I'm glad to be here. So Mr. Ashford said on page 85 of my trial transcript. So that's who Mr. Ashford is. He's a software test engineer. And for whatever reason, he was the first person that Robert Lee Broussard struck from my jury panel. So my attorney, he made what is called a Batson challenge. This is page 183 of the trial transcript, and I'll be reading it for you just to give you some context. My attorney said it picks up right here, the entire panel, there were 5. 2 of those were struck. 1 was excused for cause. So in effect, that means the state struck a majority of the African Americans tender to it. The state struck 1 for cause, Miss Winnie Ross, and then he struck Randall Ashford and Miss Vivian Jennings with what they call peremptory strikes. He said, with respect to Mr. Ashford, particularly on the panel, virtually everyone was connected with computers, or their spouse was. There was nothing unique about that. I don't recall him answering a single question affirmatively answered by either side. Like, have you ever been arrested? Have you ever been in trouble? Do you have a family member? His answers were entirely unremarkable, and I can see no reason to strike him. So the fact that he is a black male and the defendant is a black male suggests to the defense it's a race-based reason. And this is what the court responded. This is how the court responded. Let me hear your thoughts. I find there may be a prima facie showing he did not respond at all. He has not responded after telling him I'm an engineer. You know, no questions were asked that he felt like applied to him. This is what Mr. Broussard's response was. This is his response. Quite simply, I know the court is probably aware that prior to a jury week, there is compiled in our office a list of all prospective jurors. That's what he's saying here. And the record is run through our local sources of whether or not they have ever been arrested for whatever. And with respect to Mr. Ashford, it appears that he was arrested for DUI and driving without a license in 1992. That's what it says right here. Appears that he was arrested in 1992. And also, he had a probation violation. I will be happy to show Mr. Davis. And I might point out the court, he is the only person on our panel that did appear in our list. That's what he's saying right here. And I might point out to Mr. Davis, he is the only person on our panel that did it. If Mr. Davis would like to look at the remaining ones, he was the only one who appeared on our list as having a record of any sort. Court, I find sufficient reason justified by the state for that. Any others? Mr. Davis, no, sir. So, according to the prosecutor, they have a list of prospective jurors that they get week before trial. And he said they run that list of all the jurors through, and the record is run to see whether any of them have been arrested or whatnot. He said out of the 30 on my prospective jury list, only one had an arrest, Mr. Ashford, for DUI and driving without a license and a probation violation. That's what he said. He just said, okay. This list that he's talking about, we never saw the list. No one ever saw the list. I've requested discovery of the list. They can't produce it. No one's ever saw it. Mr. Ashford was never called in court and asked, are you this Mr. Ashford? Were you arrested before? Did you have a DUI? Did you have this and that? He was never asked any of these questions. Only thing we got is Broussard saying thus and so. So after trial, I went back. I had my mother to use this list of all the people who served as a juror on my trial. All 12 people, 12 jurors and the one alternate juror. And this is what we found. First and foremost, this is juror Timothy Henry Owen. See his name, Johnson Drive, Huntsville, Alabama. And you see that Mr., and let me find his name on the jury list. Let's see. This is him right here. Right here, Mr. Timothy Owen, right here. Same one, Johnson Drive. And this is the arrest report for Mr. Owen, Johnson Drive, same one. And he was also arrested for DUI. So, okay. So Mr. Broussard said that according to his list that they ran on all prospective jurors, the only one who had any record of any sort, a record of arrest of any sort, arrest. He didn't even say nothing about conviction. This is the only person that ever been arrested. Mr. Ashford, the only black man on the jury. Only person ever been arrested. Yeah. That's what Broussard said. Only person having any record of any sort. Alright. Now, I just showed you Mr. Owen's record. So we know that was a lie. We know that was a lie. But Mr. Owen is white. Mr. Owen is white. Mr. Ashford is black. So I was wondering, are they just running these checks on blacks? So here's the Okay. Let's look at juror number 14. Juror number 14. Juror number 14. Willie T. McBay, 106 Peridot Drive, Hazel Green, Alabama. Y'all can see this is the strike list for my trial. Alright. Willie T. McBay. Told you my mom, she went down to did a public record search. Willie T. McBay. Same address. All the info still the same. And what do you know? What they say, y'all? Guilty plea. Guilty plea. For what offense? Let's see what offense. What's the offense? What's the offense? Improper tag. Improper tag. Improper tag. Guilty plea. Got another one from Mr. McBay. Another one from Mr. McBay. Guilty plea. Guilty plea. What is the offense? Running a red light. Running a red light. So, the only black man is the only one that he found with any record of any sort on their list. He said they check everybody. So how come the white people's arrests ain't coming up? Public records. No records for Mr. Ashford. No list. No anything. We haven't saw it yet. We don't know what Mr. Robert Lee Broussard's list looked like because he didn't show it to us. My attorney didn't even actually see it. He just took him at his word. All right. Then we get to this one. It's Vivian Jennings. It's Vivian Jennings. Right there. Vivian Jennings, Huntsville, Alabama. Black female. Okay. Miss Jennings was on the panel. And let's see what her number is again. Number 12. Miss Jennings is number 12. Number 13, 14, 13. She's number 12. All right. Go back to the strike list again. Right here. This is the other prosecutor, Miss Lunsford. Right here. State strikes number 12. The court, 12 by the state. Struck Miss Jennings. All right. My trial attorney didn't even object to Miss Jennings. Who is Miss Jennings? Who is Miss Jennings? Hold on, let me get the transcript to show you who Miss Jennings is. Okay. Who is Miss Jennings? She is a contract specialist with the U.S. Army. Contract specialist. Government clearance. Government clearance, contract specialist. I already saw Mr. Broussard struck her from the jury panel. As I told you, my trial attorney didn't object. Post-conviction rule 32, I objected. All right. And this is what the prosecutor had to say about Miss Jennings. Right here. Start from reading right here. This is the state's response. This is the state's response. This is the state's response from Mr. Broussard. Let me see. Let me make sure that's who responded. I want to make sure I get it right. Make sure I get the name right. I'm sorry. Now, Mr. Broussard, this is the state's response that was prepared by Miss Allison Palmer. But she was not involved in trial, so her information had to come from Mr. Broussard. Okay, this is what she said. This is starting right here. This is what they said out of the Madison County District Attorney's Office said. Petitioner also alleges that trial counsel should have objected under Batson to the strike of a potential juror, Ms. Jennings. The transcript reveals that Ms. Jennings replied to a question on voir dire that she had a family member arrested in the past, specifically her son, and that she did not hear clear information as to the nature of his arrest. Petitioner has failed to show that trial counsel was deficient and has failed to carry the burden of showing that he was prejudiced in this matter. She had a son that was arrested. That's what they said. She had a son. She had a family member. It's right here at the top. Right here at the top. Family member that's arrested. She did not have clear information as to the nature of his arrest. Okay. Now, go to the trial transcript. Page 106. And you will see Miss Jennings. Alright. Alright. And this is where Miss Jennings is talking about the arrest of her son. This is what she said. She says, they first asked her, would that affect your... No, okay, he said, Miss Jennings, yes. What relation to you, my son? And what was the nature of the charge? And this is what Miss Jennings said. She said, I don't have a definite because the police just stopped him for a traffic violation and they locked him up. I don't have a definite because the police just stopped him for a traffic violation and they locked him up. And I guess I never got a full. I never got a full. No one told me exactly what it was. Only thing is I had a lawyer friend that went down there and he was released the same day and I never heard anything else about it. Never heard anything else about it. Never heard anything else about it. So you are saying that's all the time he did was that day. He never had any kind of jail sentence after that. No. Never had any jail sentence after that. No. Who is your lawyer friend? Not in this town, in my hometown. Okay. Would that affect your ability to be fair? Would that affect your ability to be fair, Miss Jennings? No. Okay. And yet, Mr. Broussard struck Miss Jennings from my mirror. I showed y'all that already. Miss Jennings, number 12, struck by the state. Where is it at? Right here. By the state. Struck by the state. Because her son has been arrested. So, I go to the trial transcript. And what do we have? I think y'all already know where this is going. Hold on. All right. Right here. Temple McCool. He was a juror. He's a white man. White male. Temple McCool. Mr. McCool was one of my jurors. Okay. And this is what Mr. McCool testified to. Mr. McCool. This is what he said. He said, back about 45 years ago, my brother ended up in jail overnight in a brawl. He was a young fellow, about 20. That would not affect your ability, Mr. McCool. I can't even remember it. He just told us about it, but he said he can't even remember. I can't even remember. Right there. Mr. McCool also had a family member spent the night in jail for a brawl. Ms. Jennings, her son was arrested for a traffic violation. They said that was why they excluded her. Mr. McCool, his brother was arrested for a brawl. What's the difference? Ms. Jennings is African American. Mr. McCool is white. Ms. Jennings' son was arrested. Mr. McCool's brother was arrested. The state struck the black woman, allowed the white male to continue on. Okay. Got one more. One more here. All right. Number 30. The first person on the list and the last one. Catherine Weather, 7906 Seville Drive. White female. A white female. That check means she served on the jury. All those with a check bound served on the jury. That's one of the African Americans who served on the jury. Okay. This is what Miss Withers testified to. She's a white female. My son was with a group of minors, of underage minors, stopped for DUI, and we had to go get him out of jail. It was probably good for them. We had to go get him out of jail. Right there, out of jail. It was probably good for him. And you are Miss Withers. Yes. And he wasn't, but he had to, and he wasn't, but he had to go through a little program that was in Tennessee. That would not affect your ability to be fair? No. All right. Now, Miss Jennings' son was arrested for a traffic violation. He didn't even spend the night in jail. For traffic violation. She was excluded. Ms. Weathers, her son was arrested underage drinking with minors. He went to jail. He had to go to a program. And what's the difference? Ms. Jennings is black. Ms. Weathers is white. Ms. Jennings was struck by the state. Ms. Weathers served on my jury that convicted me. And so, I'm just highlighting racial discrimination in the jury selection process. Why are black people being excluded for reasons that don't exclude whites? Why are you doing background checks that only showing up for black men as having a record of any sort, but it's not showing up for the white men as having a record of any sort? You the district attorney. My mama went to review your files and found this. When she went down there to review the public records files, she reviewed the public record files of Madison County that are in your office, Mr. Broussard. So how come she can find your files on your computer and you can't? Why you didn't have these records for these white jurors? Because you're discriminating. You're using race to determine who's going to be searched. That's why Timothy Owen and Willie T. McVeigh were on my jury. That's why you don't have that list you're talking about. You said my lawyer could have saw the list if he wanted to. Well, that's ineffective assistance from my counsel for not holding you to your burden of proof that what you were saying is true. One, we don't even know if that's accurate about Mr. Ashford. We never saw the list. You never called Mr. Ashford in the courtroom and asked him. My lawyer never required you to do it. There's no proof that what you said about Mr. Ashford is true. Two, there is no proof that you had a list, that you conducted a search of all jurors, and none of it showed up. We know you did. I got proof. You said that Miss Jennings was struck because her son had been arrested. But yet, Miss Weathers' son had also been arrested for more serious offense, a DUI, underage drinking with underage minors. Miss Jennings' son just had a traffic violation. She went and got in that night and never heard anything else about it. Miss Weathers' son had to go through a program. And she said it was probably good for him. And so that's how they manipulate jurors behind the scenes. He said, I know the judge is probably aware that we get a list before trial. So you know what's going on, and the judge know what's going on. My lawyer doesn't know what was going on. Defense attorneys don't know what's going on. You ain't turning this information over to nobody. You holding it back because you're doing something wrong. Yet again, busted again. I'm going to show and prove that I was denied a fair trial. I'm going to show y'all something else too. Got another document out here. I'm going to do a separate video on it. I'm going to just show y'all right quick. When you file a Rule 32 post-conviction petition, the state is supposed to respond. The judge is supposed to weigh both sides and then come out with an impartial ruling. But the way it actually works in the state of Alabama, you can look it up because the Alabama Court of Criminal Appeals has admonished judges for doing this. They allow the prosecutor to prepare the order, and the only thing they want the judge to do is sign it. And y'all see that? State of Alabama versus Melvin Ray. Why am I showing y'all this? What do you think I'm showing y'all this judge's order for? I'm going to show you what they do. The judge don't prepare these orders. Probably most of the time he don't even read the petition. Show you what he do. The prosecutor will go in there, the same order that they use to deny 10,000 other people's post-conviction petition. They just change the name. You see my name on the front? Well, look at this. That ain't my name. Who is that? That ain't my name. My name. Who is Jason Wyatt King? I ain't making this up. Page 244, 245. All you gotta do is go and pull the clerk's record. You'll see it for yourself. Judge never had any intentions of addressing any of my claims. Not a single claim. The Batson issues, the Brady violations, withholding evidence, allowing witnesses to commit perjury. He never had any intentions of addressing any of my claims. Send me an order over so I can deny it. This is the denial order. Accordingly, it is hereby ordered. Accordingly, it is hereby ordered that the petition of Jason Wyatt King for post-conviction relief pursuant to Rule 32 is hereby denied and dismissed. Denied and dismissed. They not reviewing anything. I told y'all, Chris Hedges told y'all. It's not real, it's an illusion. All these rules, all these procedures that y'all thinking people are receiving fair review of our convictions, that's not what's happening. That's not what's happening. It's on paper, but we can't get them to apply it in actual practice. They ain't applying none of this. None of this stuff is being applied. That's why, even though I got proof of racial discrimination in my jury selection process, I can't get relief. Prosecutor lying like hell. You say you just excluded Miss Jennings because her son has been arrested. Now I present you evidence that 2 more jurors had family members arrested. One, Ms. Weathers, her son, Mr. McCool, his brother. You ain't excluded the white jurors. I got proof of racial discrimination in my jury selection, which under Batson, I'm entitled to a new trial. They won't give it to me. I done discovered too much other evidence of misconduct for them to give me a new trial now. And so everybody's aligning themselves together and saying, we can't let him get back in here. He got too much. He got too much proof. We could never convict him now. He's awakened. He know what we did. He talked to Dr. Postilnik. He know we play games with the cause of death. He got the ballistics memorandum. He know we allowed them to lie about it. He got a copy of the deal for Fred Batson. He knows that Batson committed perjury and we allowed. These witnesses are no good no more. They can't use them. They committed perjury. So now they don't have a case. So what do? They hold me based on the fraud, the fraudulent case, the case full of lies. That's what they hold me on, case full of lies, because they can't afford to give me a fair and impartial trial where the truth will have to come. Because I done did my job that my attorney was supposed to do. I done went and uncovered the evidence. I done checked the jurors. I done did my post-trial investigation. I done proven their lies. They still can't tell me who provided them information about a gunshot. They did not comply with the rules dealing with the indictment. And now, I got more. On and on and on and on and on and on and on. I got it. But they won't give me my day in court. They just send me a denial order over. Didn't even change the name. Bam. Just like that. Didn't even change the name. That's not me. They changed the front of the name. They changed the name on the front. They forgot to change the name on the back. That's how I know that's what they're doing. That's all they're doing. It's a court case on this. It's a court case in Alabama Supreme Court. A judge, he signed one of these. And in the order that he signed, it said, I was the trial judge. I observed counsel's performance. They found out he wasn't a trial judge. He hadn't even been on the bench. And so the Court of Criminal said, we have admonished judges about doing this, about signing these pre-drafted orders by the prosecutor without reading them, without reviewing the petition, and just denying them. And I got proof they did it in my case. It can't get reviewed. He just signed something. Mr. Ashford, if you out there, I don't know if that's you or not on that, but if you out there, I would sure greatly appreciate it if you would come forward. Miss Jennings, if you feel like this is something important to you, if Black Lives Matter to you, if your rights as a citizen matter to you, if you feel like your integrity has been infringed upon, that they have discriminated against you without your knowledge, I wish you would come forward with me. Because I got the proof of what they're doing in Madison County under Robert Lee Broussard. That's who did all of this. He was my prosecutor. He's the district attorney now. And this proof is against him. If you're an African-American man, they're checking your background, but they're not checking nobody else's. If you're a defense attorney out there, this is a little bit more info for you to use in the course of representing your clients, if you were so inclined. If you're not like my attorney, who didn't even want to see the list, who didn't even want to do his own due diligence to go back and check. Why I have to do it and I paid him. Why I've had Archer Davis, Brian Clark, I forgot the other two lawyers' names. Not a single one of them have done this. They've been paid. So why don't they have these? Why can't they produce these evidence? Why they won't do their job? Why Archer Davis didn't require the prosecutor? Well, he didn't even want to see the list. He just accepted what the man said. He could have said, yeah, I would like to see that list. And then called Mr. Ashford. And Mr. Ashford, is this you? Because you testified that you're a software engineer on the National Missile Defense Project. Is this you? We still don't know that yet. Go and look in my file. They still have not produced that list that they said they had of this man, Mr. Ashford. And I know he said they didn't have any, no one else had any record of any sort, and we know that's a lie. Was Mr. Ashford convicted of a felony or a misdemeanor? Because those guys got arrested too. One of them pled guilty to 2 of his. So he has a record. Fighting for justice, man. Fighting for justice.